Resources. Topic 9. Employee Rights and Discipline. Reported by Beverly Jean A. Evangelista and Christian Florida. An overview of basic employee rights. Every employee has a range of basic rights in a workplace, such as freedom from harassment, fair wages, and privacy. For example, employers cannot reject candidates based on gender or race. Most companies nowadays ensure the practice of employee rights and obligations within the workplace to be able to produce a satisfactory output that is expected from the worker. As such, both the company and the employees benefit from this law. So what is employee rights? It is a human or legal right that an employee in every country has and enjoys its benefits and privileges. Basic rights of a worker enables them to perform at their best and helps the employer achieve their goals. It also implies that the worker has to be treated in a fair, morally acceptable, or legal way. Every country from a different part of the world has its own law when it comes to labor or work. Some of the employees' rights and benefits are meal breaks, paid vacation, Social Security, employees' allowance, achievement award, health insurance, pay raise, perks and bonuses. The Philippine legal basis and significant cases. Presidential Decree Number 442 of 1974, as amended and renumbered. Also known as the Labor Code of the Philippines. A decree instituting a labor code, thereby revising and consolidating labor and social laws to afford protection to labor, promote employment and human resources development, and ensure industrial peace based on social justice. The Labor Code of the Philippines stands as the law governing employment practices and labor relations in the Philippines. It was enacted on Labor Day of 1974 by President Ferdinand Marcos, in the exercise of his then extant legislative powers. It prescribes the rules for hiring and termination of private employees, the conditions of work including maximum work hours and overtime, employee benefits, such as holiday pay, 13th month pay, and retirement pay, and the guidelines in the organization and membership in labor unions as well as in collective bargaining. The code was revised and is called the Labor Code of the Philippines, renumbered Department of Labor and Employment Edition. The best way to empower Filipino workers and employers alike is by keeping them well informed on their complementary rights and obligations, says Dole Secretary, CFH Fellow 3. The Bureau of Working Conditions, a staff department of the Department of Labor and Employment, compiled a list of basic rights that every worker is entitled to. These rights ensure the safety and health of all workers. Basic rights of employees. 1. Equal work opportunities for all. The state shall protect labor, promote full employment, provide equal work opportunity regardless of gender, race, or creed, and regulate relations between employees and employers. 2. Security of tenure. Every employee shall be assured security of tenure. No employee can be dismissed from work except for a just or authorized cause, and only after due process. Just cause refers to any wrongdoing committed by an employee. Authorized cause refers to economic circumstances that are not the employee's fault. Senate Bill Number 1826, the Security of Tenure Bill. According to Senator Joel Villanueva, principal author and sponsor of the measure, and chairperson of the Senate Committee on Labor, Employment, and Human Resources Development, the bill would finally put an end to work schemes like endo and labor-only contracting. The bill focuses on A. Prohibit labor-only contracting, and provide penalties for violation. B. Limit job contracting to licensed and specialized services. C. Classify workers into regular and probationary employees and treat project and seasonal employees as regular employees. D. Provide security of tenure. E. Clarify standards on probationary employment. And F. Provide transition support program for employees while they are not at work or transitioning in between jobs. Senate Bill 1826 is clear enough to meet the interests of the labor sector and the interests of the business sector. He cited a study conducted in 13 European countries by the International Labor Organization in 2004 that revealed that the relationship between tenure and productivity for the period 1992 to 2002 shows that at an aggregate level, tenure has a positive effect on productivity for about 14 years and levels off thereafter. The study suggests that countries remain productive with a high share of long-tenured workers. Giving our workers certainty and social protection makes them more efficient and more productive, Villanueva said. The security of tenure bill is pro-labor, pro-business, and pro-Filipino, the veteran lawmaker added. Book 3, Title I of the Labor Code of the Philippines. Conditions of Employment. Chapter 1, Hours of Work. 3. Workdays and Work Hours. An employee must be paid their wages for all hours worked. If their work hours fall between 10 p.m. and 6 a.m., they are entitled to night shifts pay in addition to their pay for regular work hours. If they work over 8 hours a day, they are entitled to overtime pay. Article 83. Normal work of hours. The normal hours of work of any employee shall not exceed 8 hours a day. Article 86. Night shift differential. Every employee shall be a night shift differential of not less than 10% of his regular wage for each hour of work performed between 10 p.m. and 6 a.m. Article 87. Overtime work. Work may be performed beyond 8 hours a day provided that the employee is paid for the overtime work and additional compensation equivalent to his regular wage plus at least 25% thereof. Work performed beyond 8 hours on a holiday or rest day shall be paid an additional compensation equivalent to the rate of the first 8 hours on a holiday or rest day plus a 30% thereof. Article 88. Undertime is not offset by overtime. Undertime work on any particular day shall not be offset by overtime work on any other day. Article 89. Emergency overtime work. Any employee may be required by the employer to perform overtime work in any of the following cases. A. When the country is at war or when any other national or local emergency has been declared by the National Assembly or the Chief Executive. B. When it is necessary to prevent loss of life or property or in case of imminent danger to public safety due to an actual or impending emergency in the locality caused by serious accidents, fire, flood, typhoon, earthquake, epidemic, or other disaster or calamity. C. When there is urgent work to be performed on machines, installations, or equipment to avoid serious loss or damage to the employer. D. When the work is necessary to prevent loss or damage to perishable goods. Book 3, Title I, Chapter 2, Weekly Rest Period. 4. Weekly Rest Day. A day off of 24 consecutive hours after 6 days of work should be scheduled by the employer upon consultation with the workers. Article 91. Right to weekly rest day. A. It shall be the duty of every employer to provide each of his employees a rest period of not less than 24 consecutive hours after every 6 consecutive normal work days. Article 92. When employer may require work on a rest day. A. In case of an actual or impending emergency in the locality is caused by serious accidents, fire, flood, typhoon, earthquake, epidemic, or other disaster or calamity to prevent loss of life or property or imminent danger to public safety. C. When there is urgent work to be performed on machines, installations, or equipment to avoid serious loss or damage to the employer. D. when the work is necessary to prevent loss or damage to perishable goods. In some countries, the average working hours for full-time employees are as follows. Austria, 42.4 hours. United Kingdom, 42.4 hours. Latvia, 42.2 hours. France, 39.1 hours. Belgium, 39 hours. Netherlands, 38.9 hours. Europe, 37.9 hours. United States, 40.7 hours. Book 3, Title I, Chapter 3 of the Labor Code. Holidays, Service Incentive Leaves, and Service Charges. Article 93. Compensation for rest day, Sunday, or holiday work. A. Where an employee is made or permitted to work on his scheduled rest day, he shall be paid an additional compensation of at least 30% of his regular wage. An employee shall be entitled to such additional compensation for work performed on Sunday only when it is his established rest day. B. When the nature of work of the employee is such that he has no regular work days and no regular rest days can be scheduled, he shall be paid an additional compensation of at least 30% of his regular wage for work performed on Sundays and holidays. C. Work performed on any special holiday shall be paid an additional compensation of at least 30% of the regular wage of the employee. Where such holiday work falls on the employee's scheduled rest day, he shall be entitled to additional compensation of at least 50% of his regular wage. Article 94. Right to holiday pay. A. Every worker shall be paid on his regular daily wage during regular holidays, except in retail and service establishments. B. The employer may require the employee to work on any holiday, but he shall be paid a compensation equivalent to twice his regular rate. This rule shall apply to employees except those of the government and any of the political subdivision, including the government-owned and controlled corporations. Those of retail and service establishments regularly employing less than 10 workers. Article 95. Right to service incentive leave. A. Every employee who has rendered at least 1 year of service shall be entitled to a yearly service incentive leave of 5 days with pay. B. This provision shall not be applied to those who are already enjoying the benefit herein provided, those enjoying vacation leave of at least 5 days, and those employed in establishments regularly employing less than 10 employees or in establishments exempted from granting this benefit by the Secretary of Labor and Employment after considering the liability or financial condition of such establishment. Article 96. Service charges. All service charges collected by hotels, restaurants, and similar establishments shall be distributed at the rate of 85% for all governed employees and 15% for management. The share of employees shall be equally distributed among them. Compensation for working on public holiday in Australian government. Working on public holidays. The employees get to pay at least their base pay rate for all hours worked on public holidays. X. Christmas, New Year, awards, enterprise agreements, and other registered agreements can provide entitlements for working public holidays, including extra pay, public holiday rates, an extra day off or extra annual leave, minimum shift lengths on public holidays, agreeing to substitute a public holiday for another day, not working on public holidays. Employees, except casual employees, who normally work on the day a public holiday falls will be paid their base pay rate for the ordinary hours they would have worked if they had not been away because of the public holiday. The base pay rate doesn't include any incentive-based payments, bonuses, loadings, monetary allowances, overtime or penalty rates. 5. Wage and wage-related benefits. Wage is the amount paid to an employee in exchange for the service that they rendered to their employer. Wage may be fixed for a given period. Book 3, Title 2, Chapter 2, Minimum Wage Rates. Art. 99 Regional Minimum Wage. The minimum wage rate of agricultural and non-agricultural workers in every region of the country shall be those prescribed by the Regional Tripartite Wages and Productivity Board. Article 100. Prohibition against elimination or diminution of benefits. Nothing in the book shall be construed to eliminate or in any way diminish supplements or other employee benefits being enjoyed at the time of promulgation of this code. Article 101. Payments by results. The Secretary of Labor and Employment shall regulate the payment of wages by results, including piecework, piecework, and other non-time work to ensure the payment of fair and reasonable wage rate. Book 3, Title 2, Chapter 3, Payment of Wages. 6. Payment of wages. Wages should be paid directly to the employee in cash, legal tender, or through a bank. Wages shall be given not less than once every 2 weeks or twice within a month at intervals not exceeding 16 days. Article 102. Forms of payment. No employer shall pay the wages of an employee using promissory, vouchers, coupons, tokens, tickets, chits, or any object other than legal tender. Article 103. Time of payment. Wages shall be paid at least once every 2 weeks, or twice a month at intervals not exceeding 16 days. If on account of force majeure or circumstances beyond the employer's control, payment on or within the time herein provided cannot be made, the employer shall pay the wages immediately after such force majeure or circumstances ceased. No employer shall make payment with less frequency than once a month. Article 104. Place of payment. Payment of wages shall be made at or near the place of the undertaking, except as otherwise provided by such regulations as the Secretary of Labor and Employment may prescribe under conditions to ensure greater protection of wages. Article 105. Direct payment of wages. Wages shall be paid directly to the workers to whom they are due, except a. in case of force majeure rendering such payment impossible. b. where the worker has died, the employer may pay the wages of the deceased worker to the heir of the latter without the necessity of intestate proceedings. If the claimants are all of age, they shall execute an affidavit attesting to their relationship to the deceased. If any of the heirs is a minor, an affidavit shall be executed on his behalf by his natural guardian or next of kin. The representative of the Secretary of Labor and Employment shall act as a referee in dividing the amount paid among the heirs. The payment of wages under this article shall absolve the employer of any further liability concerning the amount paid. Chapter 4. Prohibitions regarding wages. Article 112. Non-interference in disposal of wages. No employer shall limit or otherwise interfere with the freedom of any employee to dispose of his wages. He shall not, in any manner force, compel, or oblige his employees to purchase merchandise, commodities, or other property from any other person or otherwise make use of any other store or services of the employer or any other person. Article 113. Wage deduction. No employer on his own behalf or behalf of any person shall make any deduction from the wages of his employees, except a. the worker is insured with his consent by the employer. b. for union dues, in cases where the right of the worker or his union to check off has been recognized by the employer or authorized in writing by the individual worker concerned. C. in cases where the employer is authorized by law or regulations issued by the Secretary of Labor and Employment. Article 114. Deposits for loss or damage. No employer shall require his work to make deposits from which deductions shall be made for the reimbursement of loss of or damage to tools, materials, or equipment supplied by the employer. Article 116. Withholding of wages and kickbacks prohibited. It shall be unlawful for any person, directly or indirectly, to withhold any amount from the wages of a worker or induce him to give up any part of his wages by force, stealth, intimidation, threat or by any other means whatsoever without the worker's consent. Title 3 Chapter I Employment of Women. Article 130 Article 136. 7. Female employees. Women are prohibited from engaging in night work unless the work is allowed by the following rules: industrial undertakings from 10 p.m. to 6 a.m., commercial, non-industrial undertakings from 12 meters 10 to 6 a.m., or agricultural takings at night provided that she has had 9 consecutive hours of rest. Welfare facilities, such as separate dressing rooms and lavatories, must be installed at the workplace. The following rights are for female employees. Article 130. Facilities for women. Provide seats for women, establish separate toilet rooms and lavatories, and at least a dressing room for women, and determine appropriate minimum age and other standards for retirement and/or termination. Article 131. Maternity leave benefits. Every employer shall grant any pregnant women employee who has rendered an aggregate service of at least 6 months for the last 12 months, maternity leave of at least 2 weeks before the expected date of delivery and another 4 weeks after normal delivery of abortion with full pay-based regular or average weekly wages. Article 132. Family planning services, incentives for family planning. Establishment which is required by law to maintain a clinic or infirmary shall provide free family planning services to their employees, which shall include, but not be limited to, the application or use of contraceptive pills and intrauterine devices. Article 133. Discrimination prohibited. It shall be unlawful for any employer to discriminate against any women employee concerning terms and conditions of employment solely on account of her gender. The following are acts of discrimination. A. Payment of a lesser compensation, including wage, salary, or other forms of remuneration and fringe benefits to a female employee as against a male employee for work of equal value, and B. Favoring a male over a female employee concerning promotion, training opportunities, study, and scholarship grants solely on account of their sexes. Article 134. Stipulation against marriage. It shall be unlawful for any employer to, as a condition of employment or continuation of employment, that a woman employee shall not get married, or to stipulate expressly or tacitly that upon getting married, a woman employee shall be deemed resigned or separated, or to actually dismiss, discharge, discriminate, or otherwise prejudice a woman employee merely because of her marriage. Article 135. Prohibited acts. It shall be unlawful for any employer: 1. To deny any woman employee the benefits provided for in this chapter, or to discharge any woman employed by him to prevent her from enjoying any benefits provided under this code. 2. To discharge any woman on account of her pregnancy, or while on leave or in confinement due to her pregnancy. 3. To discharge or refuse the admission of such woman upon returning to her work for fear that she may again be pregnant. Article 136. Classification certain women workers. Any woman who is permitted or suffered to work, with or without compensation, in any nightclub, cocktail lounge, massage clinic, bar, or similar establishments under the effective control or supervision of the employer for a substantial period of time as determined by the Secretary of Labor and Employment, shall be considered as an employee of such establishment for purposes of labor and social legislation. Book 3, Title 3, Chapter 2, Employment of Minors. 8. Employment of Children. Article 137. Minimum employable age. No child below 15 years of age shall be employed, except when he works directly under the sole responsibility of his parents or guardian, and his employment does not in any way interfere with his schooling. The minimum age of employment is 18 years for hazardous jobs, and 15 years for non-hazardous jobs. Article 138. Prohibition against child discrimination. No employer shall discriminate against any person in respect to terms and conditions of employment on account of his age. Book 4, Title I, Chapter 2. Occupational Health and Safety. 9. Safe working conditions. Employers must provide workers with every kind of on-the-job protection against injury, sickness, or death through safe and healthful working conditions. Article 168. Safety and Health Standards. The Secretary of Labor and Employment shall, by appropriate order, set and enforce mandatory occupational safety and health standards to eliminate or reduce occupational safety and health hazards in all workplaces and institute new and update existing programs to ensure safe and healthful working conditions in all places of employment. Article 169. Research. It shall be the responsibility of the Department of Labor and Employment to conduct continuing studies and research to develop innovative methods, techniques, and approaches for dealing with occupational safety and health problems. Article 170. Training programs. The Department of Labor and Employment shall develop and implement training programs to increase the number and competence of personnel in the field of occupational safety and industrial health. Article 171. Administration of Safety and Health Laws. A. The Department of Labor and Employment shall be solely responsible for the administration and enforcement of occupational safety and health laws, regulations, and standards in all establishments and workplaces wherever they may be located. B. The Secretary of Labor may, through appropriate regulations, collect reasonable fees for the inspection of steam boilers, pressure vessels and pipings and electrical installations, the test and approval for safe use of materials, equipment, and other safety devices, and the approval of plans of such materials, equipment, and devices. Department Order Number 178 Series 0 at 2017. Enacted and implemented A. Safety health measures for workers. WHO by the nature of their work have to stand at work. Purpose. Address the occupational health and safety issues and concerns related to the wearing of high-heeled female shoes and or standing at work for long periods. Coverage. All workers who by the nature of their work have to stand at work, such as retail or service employees, assembly line workers, teachers, and security personnel. Occupational safety and health measures. All employers, establishments are directed to institute appropriate control measures to address the risk to safety and health of workers while standing at work, which include 1. Implement rest periods to break or cut the time spent on standing. 2. Install appropriate flooring or mats that will mitigate the impact of frequent walking and prevent fatigue. 3. Provide tables or work surfaces with adjustable heights. 4. Provide readily accessible seats to be used during rest periods. 5. Implement the use of footwear which practical and comfortable. Reporting and monitoring. The covered employers, establishments shall comply and notify the department, through regional office, of the adoption of the safety and health measures as required herein within 30 days from the effectiveness of this order. Rights to self-organization and collective bargaining. Every worker has the right to self-organization, that is, to form or to join any legitimate workers' union, free from the interference of their employer or the government. All workers may join a union for the purpose of collective bargaining and are eligible for union membership on the first day of their employment. Collective bargaining is a process between two parties, namely the employer and the union, where the terms and conditions of employment are fixed and agreed upon. In collective bargaining, the two parties also decide upon a method for resolving grievances. Collective bargaining results in a contract called a collective bargaining agreement, CBA. Rights of contractual workers in the Philippines. Contractual jobs should carry the same benefits and terms of employment as permanent positions. These include the right to a safe and healthful working conditions, incentives, retirement benefits, collective bargaining, social security and welfare benefits, specific job description, place of work, terms of employment, duration of employment and terms and conditions before starting. International benchmark policies. The International Labor Organization, ILO is an organization that represents the U.S. government and participate in international and regional fora that address workers' rights issues, such as the G20, the Organization for Economic Cooperation, the Inter-American Conference of Ministries of Labor, and Asia-Pacific Economic Cooperation. The role of International Labor Organization, ILO. 1. The organization, ILO, identifies what it calls fundamental principles and rights at work that all ILO members have an obligation to respect and promote, which are freedom of association and the effective recognition of the right to collective bargaining, elimination of all forms of forced or compulsory labor, effective abolition of child labor, and elimination of discrimination in respect of employment and occupation. 2. Involved in the development and implementation of U.S. policy related to workers' rights issues in multilateral and bilateral trade and investment agreements. 3. Works with other governments to promote collaboration on workers' rights issues. 4. Conducts research and publish reports on workers' rights, including child labor and forced labor. Employment laws in the United States of America. In the United States of America, there are federal and state wage and hour laws that require fair pay and overtime pay. The Fair Labor Standards Act, FLSA, established in 1938, governs wages and overtime pay standards for public sector and private sector employees, even those who work part-time. Also, the National Labor Relations Act, NLRA, enacted in 1935, protects the rights of employees and employers and encourages collective bargaining. The NLRA is enforced through the National Labor Relations Board, NLRB, an independent government agency responsible for enforcing labor law. The FLSA and NLRA are key laws that have, through application and interpretation by court decisions, greatly advanced employee rights. These statutes, along with labor union disputes, led to the creation of open shops, where membership in a union was allowed but not required in traditionally unionized industries. Five countries with the best employment laws. 1. Austria. When it comes to the number of paid holidays, Austrian workers are lucky they get an overall of 43 days off from work, and that's not even counting parental leave. 2. Belgium. Compared to other European countries, Belgium has the highest wages. Belgium can, however, do a better job with its parental leave statutes. 3. Denmark. The law in Denmark does not allow any kind of discrimination in terms of hiring specific workers or terminating contracts because workers are a part of trade unions. In Denmark, each worker is allowed 25 days of paid holiday leave per year. 4. Finland. A country known for its employee-friendly employment laws, Finland is famous for the number of parental leave days offered to workers. Employees are entitled to 105 weekdays of paid maternity leave law, and fathers are permitted 54 days of paid paternity leave. According to the new reform to parental leave law, parents will be able to enjoy 164 days of paid parental leave, effective 2021. 5. Germany. In Germany, workers' rights are a necessity. That is why Germany is a country with some of the best employment laws in the world. Here, workers are allowed a minimum of 20 days off from work each year. Germany is also among the top 5 countries for minimum wage, coming out at €9.35 per hour. Mothers are entitled to 13 weeks of paid maternity leave, including 6 weeks off that they can take before delivery. Fathers are allowed to share a 3-year leave with their partners. That's a wrap for my report about employees' rights. I hope you enjoyed the show. That's all, and thank you for listening.